moderating today's webinar on the environmental justice implications of changes to the National Environmental Policy Act, also known as NEPA. We're fortunate today to have two panelists with extensive experience in advocating for environmental justice communities, share their expertise, and also ways for communities and everyone else, for that matter, to get involved in what we believe is a very dire threat to NEPA. Our first panelist or expert for today is Ms. Marianne Engelman-Lado, civil rights lawyer and lecturer of Yale School of Forestry and Environmental Studies. Marianne also serves as the WEACT's board of director, where she serves as secretary. Second, we have Ms. Vernice Miller-Travis, who is one of the founders of WEACT and the senior advisor for the environmental justice and equitable development for SKEO Solutions. Vernice also serves on WEACT's board as well. Before we start, we would also like to recognize Anna Carcamo and Jesse Bryant from Yale University for their assistance and research. Both Anna and Jesse will be graduating next week with masters in environmental management from Yale University. So before I turn it over, just to let you all know, feel free to use the chat feature throughout the webinar, and we'll try to log those questions to be answered later on during our Q&A period. And now I will turn things over to Ms. Vernice Miller-Travis. Thank you so much.
Vernice, are you jumping in? Make sure you're not on mute. Kerene, do we know whether Vernice is on the phone?
I see her. I see her listed. Vernice?
I'm not sure what to do. Should I jump in and then Vernice can take it from there? Can you all hear me?
Yes, we can hear you.
Okay. If Vernice isn't jumping in, maybe I'll just start. And as soon as we can hear Vernice, I cede the floor to Vernice. So it's great to be on the phone or on this webinar with all of you. Thank you so much, Kerene, and thank you, WEACT, for pulling this together. We're going to talk about NEPA, and many of you probably have experiences with NEPA, weighing in and sharing your perspective, maybe being frustrated. We'll hear about that too, but weighing in on projects with that have significant federal involvement. And maybe you've also been involved in what are called little NEPAs, or state policy review processes. About 20 states have statutes, have laws that also are intended to engage people around projects with significant state involvement. So we're going to talk about both, and we're also going to talk about the threat to NEPA, and that provides a certain amount of urgency to this call. So we hope you're all familiar with NEPA. We hope you all get involved in projects and weighing in on projects that affect your future and that have environmental justice aspects to them, that that threaten communities, that might pave roads through communities, whatever it might be. But we also want you to know about some recent developments and hope that you'll get involved. So to start out, what is NEPA? NEPA places an obligation on agencies at the federal level to consider every significant aspect of environmental impacts of a proposed federal action. And so it puts this obligation on federal agencies that's really quite demanding. They can't just pass or get involved in something or put money behind a proposal without considering all aspects, all environmental impacts of a proposed action. Equally important, NEPA ensures that the agency will inform the public that it has considered these impacts in decision making. So NEPA was enacted in 1969. It's part of the whole environmental movement. President Nixon signed it into law in 1970, and it was the first major environmental law, sweeping environmental law to make sure that people are aware of the environmental impacts of federal actions, and it's the basis of this country's commitment to national environmental policies. As I said, the law requires that agencies assess the impacts of projects, and we're going to get into more of the details of what that assessment requires. If Vernice has joined me and wants to take the baton, this is an invitation to do so. Otherwise, we'll move on.
Fine. Can you hear me?
Yes. Great.
Okay, good. Next slide. So, as Marianne said, and probably it's more appropriate for her to do this slide, but in Section 242 USC's Section 4321, the purpose of this act is to declare a national policy which will encourage productive and enjoyable harmony between man and the environment. Obviously, this was from a time before we tried to make the information in our federal laws gender neutral, to promote efforts which will prevent or eliminate damage to the environment and biosphere, and stimulate the health and welfare of man, to enrich the understanding of the ecological systems and natural resources important to the nation, and to establish a council on environmental quality. And that's a very important component of NEPA. It established the White House Council on Environmental Quality, which still exists today and is the main entity that advises the White House on environmental policy at a very high level. It works with all the environment and natural resource and public health agencies in the federal government, but it is the main entity that the White House turns to drive policy. In terms of relevance to environmental justice, this is a critical protection for frontline communities such as people of color, low income and indigenous peoples, and it's an opportunity for communities to know how projects will impact the environment in their communities and for them to provide input on those decisions. And these are federal projects that we're talking about. So airports, highways, ports, nuclear facilities, military bases, federal housing projects, federal institutions like prisons and federal government buildings. So these are projects where the federal government has a decisive role either in advancing the project, or there's a tremendous amount of federal oversight and or federal interest in what this project is. Next slide. The NEPA process requires that recipients of federal funds perform an environmental assessment, or an EA, and in those environmental assessments, they should consider public involvement, alternatives, including the alternative of not continuing with the project. That's a very important piece. Direct, indirect, and cumulative impacts. And so where the environmental justice constituency has really elevated the conversation over the past 30 plus years about cumulative and synergistic impacts, that concept of cumulative and synergistic impacts was first articulated in the National Environmental Policy Act. Next slide.
You know, before you go on, let me just say one thing about effects, that the effects that the agency look at includes all kinds of effects. So often people talk about environmental effects, but it includes public health effects, safety effects, the unique characteristics of the community.
Absolutely.
You can weigh in on historical sites, the cultural significance of a site. So think about direct, indirect, and cumulative impacts as really broad, those impacts on the range of interests on the human built and natural environment, not just, be very clear, not just the natural environment.
Excellent point. Next slide. So in the Executive Order on Environmental Justice, Executive Order 12898, there was a memorandum that accompanied the executive order called the Presidential Memorandum, and this stipulated and outlined all the various components that the federal agencies and federal government were being tasked to address and to undertake by President Clinton when he signed the executive order on environmental justice. And so it specifically recognized the importance of procedures under the National Environmental Policy Act for identifying and addressing environmental justice concerns. That's very important because up until the time that the executive order on environmental justice was signed in February of 1994, NEPA had all of this language that we spoke about and that Marianne and I have just articulated and you see before you on the screen, but it wasn't directly connected to environmental justice communities, communities of color, minority populations, low income, indigenous and tribal communities. The executive order helped to really spell out and articulate that connection between NEPA and advancing environmental justice. So again, it identified the procedures under NEPA for addressing environmental justice concerns, and then this accompanying authorizing memorandum stated that each federal agency shall analyze the environmental effects, including human health, economic, and social effects, analyze the effects of federal actions, including the effects on minority and low-income communities, when such analysis is required by NEPA. So when you're doing that environmental assessment that we mentioned previously, you now, as of the passage of the executive order on environmental justice and the signing of it in 1994, you also have to make sure that you're analyzing the effects of federal actions on communities of color, low-income communities, when such an analysis is required by NEPA. Next slide. The memorandum also stated the importance of NEPA's public participation process, directing that every federal agency shall provide opportunities for community input into the NEPA process as a very, very, very important, identify potential effects and mitigation measures in consultation with affected communities, and improve the accessibility of meetings, crucial documents, and notices. Next slide. Marianne, who's talking about process, you or I?
I can jump in.
Okay.
So what we wanted to do, and this looks like a messier slide than it really is, but what we wanted to do is just outline the process. And many of you probably know pieces of this process, or in fact the whole thing. And some of you may have participated in a NEPA process, not even knowing necessarily that it was part of the NEPA process. So what happens? It starts at the top of this page where an agency identifies a need and develops a proposal. So let's say there's a new highway and an agency in a state says, we're gonna go to the Department of Transportation to get money for this new highway or to get approval for this new highway. Or let's say I'll talk later about a situation in Arkansas where there was a big pig facility that was going to affect a low-income community, and they went to the U.S. Department of Agriculture to get backing for a loan, but it's $4 million of a loan, so that's a really significant project. So CEQ, as Vernice said, they have their own regulations governing what's a significant project, try to define all the terms we're about to talk about, but then each agency has its own regulations modeled after CEQ, but saying if I'm in the US Department of Agriculture, what's a significant project? When do I have to go through the process we're about to talk about? So each agency, they develop a proposal for something, or they're ready to take action on something, and they should look at their guidance documents and regulation to say, okay, is this a significant enough proposal that I have to go through this process? And if it is, the first question is, are impacts of this proposal likely to be significant? Now, in some cases, there's something called a categorical exclusion. And I'll just use an example of a state process. Recently, in an area I work in, Alabama, there were $4 million that were put aside from a rainy day fund to modernize a sewage treatment plant. And there's a question in my mind as to whether or not that will fall under a categorical exclusion. There's a regulation in Alabama that says if you just upgrade your sewage plant or a facility, that you don't have to go through this process, at least at the state level. of doing an environmental impact. So they already have this sort of broadband categorical exclusion. And if it's valid, unless there are extraordinary circumstances kind of reading down that line, then they can just make a decision there's no extraordinary circumstances, and they can go ahead and just do their project unless someone challenges them saying this categorical exclusion was wrongly applied, or this kind of upgrade doesn't fit the categorical exclusion. And that's a point I want to make, which is if you don't know whether the, say, categorical exclusion is valid, or if you think you're in for a long fight, at the very top of this chart, when you know that a agency at the state or federal level is about to do something that you think is significant, you might want to also contact a lawyer in your state, someone you've worked with, someone who might know environmental laws or civil rights laws, but might be willing to work with you to figure some of this out. Because maybe the state of Alabama is saying there's a categorical exclusion when they shouldn't be. And so thinking that through and not accepting a government decision is part of the NEPA process, and thinking about when it should be challenged. Okay, let's say there's no categorical exclusion. Then you go back to figuring out of the impacts, whether the impacts of this project are likely to be significant. It may be uncertain, and so the agency has to do an environmental assessment. And that environmental assessment, they have to look at a whole bunch of factors, including, just as we talked about, the effect on public health and safety, the unique characteristics of the community, cumulative effects, all those things, alternatives, including not going forward with the proposal, the no alternative idea. So they have to go through that to assess whether there are any significant impacts. And if there are significant impacts, then they have to go on to do an environmental impact statement. If there are not significant impacts, they make a FONSI, a finding of no significant impacts. Before they do that, though, they issue a draft environmental assessment. And that's why that box, EA, with public involvement to the extent possible, that's one of the reasons that box is green. Green means this is one of the many places where you all can play an important role. When they issue that draft environmental assessment, people in the public can comment on it. And in your comments, you can not only raise objection with their draft, you can say, well, they said there were no significant impacts, but in fact, they totally disregarded, that a cemetery will be affected, and that's a sacred spot, and that has environmental justice impacts, or whatever it might be.
Marianne, if I could jump in for a minute. So one classic example of this, if you've ever heard me present on the history of West Harlem environmental action, you've heard me talk about the North River Sewage Treatment Plant and what a bane that was to our existence. In the process for designing and siting the North River Sewage Treatment Plant, EPA Region 2, early in its existence in 1972, gave two findings of no significant impact for a sewage treatment plant that was designed to treat 180 million gallons of wastewater a day. That's across the street from where 100,000 people live, that had no odor control systems built into the original design of the plant. And that was what we were fighting with EPA and the state of New York and the city of New York about, is that they designed a huge process and a huge project using $1.1 billion of mostly federal money without determining what the environmental impact was going to be on the adjacent community. And surely if you're treating 180 million gallons of raw sewage and wastewater a day that just sits in the plant and gets treated and doesn't move and just sits there, odors are going to happen. How could you not think that there would be a significant environmental impact on the adjacent population? And that's what we sued and litigated and won against the city of New York and the state of New York for. But that's why this is so important, because other people make determinations about what is a significant environmental impact without really thinking about adjacent or nearby communities and populations and how that facility might impact populations, because the desire, at least in New York, was so intense to see a sewage treatment plant come online to help clean up the pollution in the Hudson River, that they discounted the impact on the quality of life of the community of color that lived across the street from the plant. So this is This is a very important thing that's been used many, many, many times to barrel over and erase community impact.
Yeah, that's such a great example. And it's also a really great example of how commenting on a draft environmental assessment can actually lead to successful litigation. If you comment on the draft environmental assessment and say it failed to take into account all of this sewage that's going to be sitting here without adequate protections, as an example, the agency, well, the NEPA process doesn't determine the outcome. It doesn't have to agree with you. It does have to consider what you've put into the record. So if it fails to consider what you've put into the record, your comments, when you comment, that goes into the official record. And if they fail to consider what you've put into the record, there's a lawsuit there. And that's actually how we get the requirements of the EJ executive order to actually have a lot of teeth. Because if you comment on an environmental assessment and say there are going to be environmental justice impacts, and here's where the facility is, and here's who it's going to affect, and it's going to have significant effects, and it's going to affect people of color, or whichever group it might be, and then the agency fails to take that into account, there's a lawsuit there. You can file under an Administrative Procedures Act and say their actions were arbitrary and capricious. We're going to talk about an example. The Dakota Access Pipeline actually was a fight over the environmental assessment because the Army Corps of Engineers failed to respond to an environmental justice assessment and the needs of the Sioux and others who had put information into the record. Let me keep going. Because if the agency then says, oh, there's a finding of no significant impact, they ignore your comments or they take into account your comments, but there's a finding of no significant impact, you can challenge that. Or they can say, okay, we did in our environmental assessment and we actually realized there are going to be significant impacts. And so either as a result of a challenge or as a result of their own analysis, we go back up to that third column where it says significant impacts may or will occur. That's not the end of the story. If there are significant impacts that may or will occur, then the agency issues a notice of intent to prepare an environmental impact statement, and they get involved in what's called public scoping, where they have a meeting and they have notices. And this is another really important place where you can weigh in and say, well, gee, they're saying that the scope of what they're going to look at is, say, that this proposal is going to affect, I don't know, people within 100 yards. But in fact, the smokestack is going to bring air pollution to an area of a mile. And so the scope of what they look at has to change. Whatever it might be, you have another opportunity to weigh in. And then the agency takes all that into account, and they're supposed to look at the alternatives. They're supposed to look at the impacts, again, all the public health impacts, environmental impacts, all the things we talked about before. And then they do a draft environmental impact statement. Once that draft goes out, you have another opportunity for weighing in and putting information into the record and commenting. And then the agency has an obligation to take that all into account, and they issue a final environmental impact statement. That final environmental impact statement is available. There's another opportunity to weigh in, and then there's a record of decision.
So let me
go ahead.
Let me just comment on the significance of the environmental impact statement, which I'm sure you all know. If you're on this webinar, you have encountered environmental impact statements or maybe even tried to be involved in one or intervene in one. This is where it's really critically important that you mobilize your communities, to bring in some outside experts, local academics, planning folks, folks with a science background that you know or have a relationship with your organization, or you need to develop a relationship because you need to really bring your A game when you are trying to respond to an environmental impact assessment. This is the document and the thing that's going to define the the boundaries of what gets done in this project, levels of pollution emission, how they will try and capture those or redirect them or mitigate them. This is really the guts of the project, is what's codified in the environmental impact statement. So all the opportunities that, that Marianne just laid out for when you can get involved in the EIS process, you must take advantage of that. Because if you wait until after this process is over, it's really, really hard to go back in and reopen an environmental impact statement once a final EIS and a publicly available final EIS has been made available. Once that record of decision happens, it's really, really hard to go back in and reopen it. Some people have, but it's very, very difficult. So you should take the opportunity in that process, when the notice of intent goes out and the public scoping is happening. That's when you really have to get involved, and you really have to participate in the public review and comment process. That is your opportunity to shape the outcome of the project and to influence what the environmental impact statement ultimately looks like and how it comes out as a final document.
Yeah, and we can go to the next slide. We're not going to go through these key terms. We just want you to see that the slide has definitions of some of the words, the terms we use, like an environmental assessment or a finding of no significant impact. And I think, Kerene, you're making the slides available afterward, and so this is a resource for people.
Yes, we will be.
Okay. And the other thing, as we go on to the next slide, that I just want to emphasize is that during that process, many of you are involved in connecting with lawyers or connecting with social scientists or epidemiologists. There are some of our partners like Jacoby Wilson who do health impact assessments connected to communities. These are all extremely useful technical assistance providers for you. So if you know or you are concerned that a project will have a negative impact on your community, or that there are ways of mitigating, or that there are alternative projects that would be better, these are opportunities to ask those technical assistance providers if they will help you to weigh in on projects that have federal involvement or state involvement. Now what we wanted to do is talk about how it's been used, and Vernice, I can give a couple examples and then leave it to you, or do you want to start?
No, you start.
Okay, so the two I wanted to talk about are both examples where communities have successfully challenged environmental assessments because the agency has failed to give adequate consideration of what communities have raised, or they've done a bad job of their assessment. And let me I'll tell you about one where I was not personally involved and then one where I was. Neither was what shut down the facility. So they're both, you could say they're both stories that aren't entirely successful. But both of them gave leverage and life to community organizing. And I think that's really important, not only to force federal agencies to mitigate or to pay attention to community concerns, but sometimes when the stars are aligned, sometimes you just have that leverage that can make a change to the outcome. And sometimes the legal work is just really helpful to the community organizing, and that was true in both of these cases. And in fact, in the second case that I was involved in, it may actually be affecting the outcome completely. So I'll get to that. So as you all know, it got so much attention. The Dakota Access Pipeline transports oil from the Bakken oil fields in North Dakota to a storage hub in southern Illinois. The Dakota Access Pipeline raised concerns. The pipeline was crossing sacred lands that are important to the Sioux tribes, Standing Rock, Cheyenne River. The pipeline was crossing the Missouri River across these sacred lands, and as you know, there was an enormous mobilization. And a suit was filed with the Earth Justice's help in 2016. There were a number of suits including suits on the First Amendment that the pipeline would desecrate sacred waters and interfere with the exercise of religious beliefs. And a number of these challenges failed. But what then happened is they filed a challenge to the environmental assessment, saying that the analysis of the environmental impact of the pipeline crossing the Missouri was in violation of NEPA because it didn't adequately consider the impacts of an oil spill on fishing rights, hunting rights, or environmental justice. And the court ordered reconsideration of those sections of the environmental analysis. Now, it wasn't entirely helpful in the sense that, as you know, the Trump administration came in, and also the court declined to hold up the pipeline operations. They said they wouldn't hold up pipeline operations while the Army Corps did its analysis. But at the time, there were so many lawsuits that had failed, it gave a shot in the arm to the movement. The court looked at some of the things that we were talking about, that the Army Corps of Engineers had failed to require consideration of impacts, the environmental impacts of the action, and they had done a finding of no significant impact, despite the fact that they hadn't adequately reviewed the environmental justice impacts, the cultural space, the historic space, the infringement on the sacred space for the tribes. So the court evaluated the FONSI, the finding of no significant impact, with what they call a hard look at the adverse environmental effects. And they asked, did the agency adequately identify and evaluate those effects? And they found, in fact, that the EJ analysis, the environmental justice analysis, was arbitrary and capricious. And though under the EJ executive order, the agency doesn't by itself have to do an EJ analysis, here they had, in part because the tribes had raised environmental justice, and once they had done it, they couldn't do it in an arbitrary and capricious way. And so they had failed to take a hard look at the consequences of this proposal. Of course, I'm cramming all of that into a very, very short story. It's such a complicated issue, and the litigation continues with the Army Corps of Engineers issuing another decision affirming its original decision to issue the construction permit. A similar but maybe ultimately happier story, but similar in the sense that getting involved in NEPA and getting lawyers involved at the same time, and raising the failure of the agency to take a hard look, and that providing a lot of leverage for the community to organize and raise some serious concerns, was a case we brought when I was at Earth Justice on behalf of the Buffalo River Watershed Alliance and other organizations in Arkansas, and including the National Parks Conservation Association. It was in challenge to a 6,000 pig facility on the banks of the Buffalo National River. Now, the Buffalo National River is 135 miles of free-flowing water. Some of you may know it. It's in Newton County in the Ozarks, which is a low-income community. And the potential impacts of this huge swine facility on this area, and it's an area where the ground has fissures in it, so when they spray the pig waste, which is what they do, they have the pig waste out in these open waste pits, and so it smells, and then they spray it on spray fields, and then the manure can go down into these fissures and out into the water. And this is a community that's low income and depends on tourism. It obviously was not compatible. So I found out about this case when the National Parks Conservation Society sent me a critique of the environmental impact, the environmental assessment that was made actually by the National Park Service. They said the environmental assessment was done by the Farm Services Agency. And in fact, the Farm Services Agency said that it had consulted with the National Park Service because the Buffalo National River is a unit of the National Park Service. And in fact, they hadn't, that was a lie. And so what had happened was, this is a facility that was a contractor to one of the huge multinational swine companies, in this case Cargill, which is now owned by a Brazilian company, JBS. They got $4 million in backing for loans from the Small Business Administration and the Farm Services Agency. This was definitely a major federal action under Small Business Administration and Farm Services Agency regulations and operating principles. The Small Business Administration had never done any environmental assessment at all. The Farm Services Agency did this terrible one that not only did the National Park Service say that they had not told the truth about consulting with the National Park Service, but there were about 41 other ways in which their environmental assessment was defective. So we went to court and challenged their environmental assessment, and it was found to be inadequate. And the court said, that the environmental assessment hadn't mentioned key resources in the area, hadn't mentioned the potential for impacting the waterways, hadn't addressed alternative locations, and that they made conclusions without explanations. And so the court said the agency was duty-bound to explore how the farm might affect the environmental identity and natural resources of the area, to analyze alternatives and propose to mitigate any environmental consequences that might flow from the farm, and they forced them to redo the assessment. One thing led to another, though the court didn't order the farm closed or anything, but people galvanized about weighing in on that new environmental assessment. They galvanized about weighing in on the next permit to the state government, and recently the state government denied the facility's permit to operate in November 2018. So, and that denial is still on appeal because the Farm Bureau will fight anything. But it just shows how if you coordinate your NEPA strategy with a larger strategy and use it to engage and mobilize, it can really make a difference. And I know, Vernice, you have some additional examples.
So, two examples that I'm going to go through quickly. One is from North Charleston, South Carolina. So North Charleston is a separate jurisdiction from Charleston. It is just the north part of the city of Charleston, but is a separately incorporated city. It is also where the port of Charleston is located. And so many ports across the United States, with the deepening and broadening of the Panama Canal, it's allowing bigger cargo ships to come through the Panama Canal and get to the Americas. And so most of the ports in the United States are going through a process, or have gone through a process of deepening the rivers or the water bodies that lead up to the ports, and expanding the transportation corridors around those ports, because now you'll have ships that are twice as big as the ships that used to arrive. And so you'll need more vehicles to be able to get in and out of those ports and move goods and services. I'm not going to even discuss the impact of the vehicles on the communities, because for the purposes of this, I just want to talk about the road corridor leading up to North Charleston. And so the community itself recognized that there were major impacts that were going to come from the deepening of the Charleston River and the expansion of the Port of Charleston around their community. And so their community, like many EJ communities, abuts many industrial land uses, including they are cheap jowl with the Port of North Charleston. And as the port was going to expand, the environmental impacts and the public health impacts, the transportation impacts were going to be deep and broad across their community. And so they reached out to the city of North Charleston, and they, by fluke and by luck, they landed on the desk of Miss Juanetta. I want to say her last name is Williams, but I think that's wrong. But she worked for the city of North Charleston, and she was a transportation planner in the city of North Charleston's local government. And when the community came to her and said, we're really concerned about what the impacts of the expansion of the Port of North Charleston are going to be, we would really like to get engaged in this process about how decisions are being made. And so she did some research. She recognized in her research that there were two avenues that had not been broadly used, but who that had a really solid foundation on how to raise the concerns of this community in the environmental impact statement process and the whole NEPA application process around the expansion of the Port of Charleston. She looked at Title VI of the Civil Rights Act and the Executive Order on Environmental Justice. And she said both of these documents had significant avenues for how you interact in that process and raise up the issues of the disproportionate impact and potential discrimination against people of color and communities of color and low-income communities. And so she filed an effort to intervene in the process on behalf of the community in conjunction with the city of North Charleston, and they raised such good and solid issues that they had to be allowed to intervene in the process because the impacts on them were going to be immediate since they lived adjacent to the port itself. They went through the process. It can be very Byzantine. That diagram that Marianne walked us through is just one snapshot of the many, many, many steps that you have to go through in the NEPA process. But since she was a transportation planner, she could really help them and provide technical assistance to the community to really learn and understand the process, but to be fully engaged in the process. And so they went through the process and they ultimately raised the issue of the potential for mitigation funds to come to the community to be able to thwart some of the adverse impacts that the expansion of the port was going to have on the nearby community. The federal government and I think I'm trying to remember what the authorizing agency is here. I think it is the Environmental Protection Agency and the U.S. Department of Transportation agreed with the claims that the community made. And for the first time in the history of NEPA, which at the time I think was probably 45 years old, today it's 50 years old, they agreed and affirmed the community's complaint that they raised and the issues that they raised about the environmental impact, and they awarded them a $4 million mitigation fund. Now, in the scope, the total dollars that are being used to expand the port and the goods and services that are going to flow through, this is a drop in the bucket in terms of the total amount of dollars that are on the table. But it was the first time in history that a community, particularly a community of color, had actually gotten an affirmation of the claims that they raised, and they were given $4 million, a $4 million mitigation fund to try and thwart and abate some of the impacts, and also to try and raise the awareness of the community of what the potential impacts are going to be. Lots of back and forth between the community and the city of North Charleston. The city of North Charleston held on to the funds for them with the community's approval, but then it got to a point where the city of North Charleston did not want to release those funds to the community, and they had this employee of the city who railed on behalf of the residents that this is their money and you cannot hold on to the money. They fired her. And she set up her own firm, and they eventually did get that money. And then they came back a second time and have now since gotten a second tranche of $4 million in another mitigation fund. So they've actually gotten $8 million in mitigation funds to do planning, to build more affordable housing, to do air monitoring, to do a whole host of things that are going to try and protect the community from the adverse effects of the growth of the port. The other one I want to talk about just quickly is Corpus Christi, Texas. Corpus Christi also has a port, the Port of Corpus Christi, that is already huge and is going to expand to let those bigger ships come in from Panama Canal. And they had determined, the state of Texas Department of Transportation and the person who represents the Federal Highway Administration that's based in, I think in Texas, they had already determined that they were going to expand the highway, which was going to eradicate a part of a historic African-American and Latino community that had already been severely damaged and diminished by highway expansion going in and out of the port of Corpus Christi over a 30-year period. This next hit that the community was going to observe was pretty much going to wipe the community off the face of the earth. And the community raised up and said, you know, the highway expansion to service the port should not be layered on top of or decided to be of more value than the lives of the people who live in these two historic communities. They linked up with the University of Texas at Austin Environmental Law Clinic, and got involved in the environmental impact statement, but their issues were not being heard. And so the resolution of this issue is about relationships. So my firm that I work for is a technical assistance provider to US EPA. And I was asked by one of the officers at EPA if I would get on a conference call with all these folks in Texas, not the communities, but the agencies, to talk about a final meeting that they wanted to have, do something called the record of decision that Marianne talked about in that process. That's the last step. When you're doing an environmental impact statement and study under NEPA, the last final thing that dots all the I's and crosses all the T's is a record of decision. They were about to sign the record of decision, but they were required to have a public meeting. And they wanted to know if I would come to Corpus Christi to facilitate the public meeting. So we're on the phone, we're having a talk, and I say, so what does the community want? I said, I know these people in Corpus Christi. I know that they want air monitoring. And so since you're going to expand transportation corridors and expand the highway, I'm sure that they want local monitors in their community. And the local, the Corpus Christi person says, well, nobody has raised that. I said, I can't believe that nobody has raised that. I said, well, what about the alternative analyses that are required under NEPA? What about the NEPA analysis? Have you done that? And he said, well, we've done it to a limited degree, but the community didn't ask for it. I said, I just can't believe the community hasn't asked for it. I said, so before I would come to Corpus Christi to facilitate a meeting, I need to know what engagement has happened with the community as required under NEPA. What have you heard from them, and how are their interests reflected in the environmental impact statement? And then I didn't hear from them anymore. But I heard from the folks at EPA that they were very, very angry that I had come into the process at their invitation at the last minute and raised all these community concerns. I said, well, that's what the law requires. That's why it's important to read statutes, read the guidance, read the documents, so you know when you sit down at the table, what are people required to do? Well, I knew what NEPA was required to do, but I also knew that they were trying to pull a fast one. So I got off the phone with them. Nobody asked me to do this, but I knew that they were trying to get this under the wire so that they could go ahead and do this $600 million project and not care a whit about what the impacts were going to be on the local community. I happen to have a close personal friend from New York. I'm from New York. The person that I reached out to is from New York. He was the assistant administrator for civil rights at the Federal Highway Administration. And I called him and I said, your people in Texas are about to sign off on a big, huge project that's going to devastate 2 Black and Latino communities in Corpus Christi, Texas. And if they sign off on this, this is going to be hell to pay for the Office of Civil Rights at the Federal Highway Administration. I think he probably hung up the phone with me and called his people in Texas to find out what was going on. They stopped the process. They did an investigation, which they were required to do under Title VI of the Civil Rights Act. They stopped the whole clock, did that process, found that in fact there were going to be adverse impacts on this community, and they stopped the project. Everybody in Texas was pissed off at the Federal Highway Administration. This issue went all the way up to the Secretary of the Department of Transportation to say that either we have these laws and these guidances and these civil rights protections to protect people's interests, or we don't. And our job is to enforce those laws. And so they did mitigate the project significantly so the highways would not run through these communities, and they really scaled back the project. So when you know what you're doing, you have the law on your side sometimes, but sometimes it's about who you know. And the communities down there never knew that I made these calls on their behalf, but because I knew them, and I knew how long they had been struggling in Corpus Christi against these big industrial facilities and the long-term impact on the community, I was able to connect those dots. Why am I telling you this? Because sometimes the relationships that you have with people in government, out of government, in the private sector, in academia, of course, all our civic leaders and all our community leaders, those personal relationships sometimes can be the thing that get people to listen to you when process and practice and requirements and statutes are not bearing out. Sometimes you got to pick up the phone or go and meet with people to draw their attention to what's going on and make them pay attention so that they can intercede on behalf of people. And that's what happened. It happened at the headquarters level, but because people were really organized in Corpus Christi that they could stop this process going forward. Those are my 2 examples.
Thank you. Let's move to the next slide. Those are such important examples. But we want to make sure to have at least a few minutes for Q&A, and we have one more topic we want to touch on. I'll start us out. So as you all know, NEPA is a federal statute, but the statute itself says that CEQ, the Council for Environmental Quality, is the coordinator of this, and CEQ regulations have been really important in teasing out the fact that agencies have to consider cumulative impact, for example, or what participation is required, what meaningful participation is required, or what do the hearing opportunities look like. And all of this is under real threat right now. And what do I mean by that? As you know, in 2017, President Trump signed, I shouldn't have mentioned his name in this, I apologize, but in any case, he signed an executive order 1307 to speed up infrastructure projects and instructed CEQ to ensure that agencies apply NEPA in a manner that, and I'll use their words, reduces unnecessary burdens and delays as much as possible. Now, what's an unnecessary burden to one person is a necessary opportunity to have input to another. And so what that did was say to NEPA, say to CEQ, y'all have to change your regulations. And indeed, they put out an advance notice of proposed rulemaking last year in the name of reducing, quote unquote, unnecessary burdens and delays and simplifying and accelerating the review process. This advance notice asks people to weigh in on how the regulations under NEPA should change. So they're not going to change NEPA itself, but they'll change the interpretation of NEPA. And the idea, as some of you may have signed on to comments, but the idea there was for communities to not invite CEQ to change the regulations, to just try to hold down the fort as long as we can in this administration. But what we expect is any day now, and it was on there's an agenda for rulemaking, it was on the agenda of CEQ for earlier this spring, actually in February, so we expect it any day. Once the agency has taken into account comments that were submitted for the advance notice of proposed rulemaking, they'll post in the Federal Register a notice of proposed rulemaking. That's that NPRM, the Notice of Proposed Rulemaking. And when that notice of proposed rulemaking comes out, we expect they're going to try to cut back on consideration of cumulative impacts. They're going to try to cut back on consideration of public health. They're going to try to cut back on the opportunities, the timeline for people weighing in. And that's why it's so important to really understand what NEPA, not only what NEPA has provided in the stories we talked about, but what it could provide. And to push for a more robust, a stronger NEPA and weigh in. And this is going to require real mobilization to make sure people know what is happening, to make sure people know how important NEPA is as an opportunity to have input on projects affecting your community, and to get as many comments as possible. This is in part a time game that the administration we hope, has only a couple more years. And if they can't get these rules across the finish line, we may be able to save and even strengthen NEPA rather than see it weaken. And they have to respond to comments that are in the record. So if you submit comments, they'll have to respond to them. So WEACT and the folks of us at Yale have been working together to try to get some comments together that are ready to go. But all of you can both sign on to comments that people submit and write your own comments, or have comment parties where people send in postcards or send in letters saying how important it is that community voice be heard. So we wanted to give you the heads up that this notice of proposed rulemaking may be coming out any day, and we'll have to organize and mobilize to preserve and fight for strengthening the processes to have a voice in decisions affecting EJ communities. Vernice, you can have the last word, and then we should definitely take at least a few minutes of questions.
Just that this is, as Marianne has said, a very important opportunity. And one thing that we tried to do during the Obama administration was to provide technical support to EJ groups and communities all over the country to be more engaged in the rulemaking process, because that's where EPA codifies rules and regulations. So Congress will pass those rules and regulations and statutes, but EPA will go through a notice of proposed rulemaking, and that's where the rubber hits the road. So you have to be involved in that process so that your interests, your ideas, your suggestions, your recommendations, and the things that you don't want to see happen can get incorporated into that final rule. So I'll leave it at that, and let's take some questions.
So we're going to open it up for some questions. You can either type it in the Google chat, or I'm sorry, in the Zoom chat, or if it's a short one, feel free to unmute yourself and I'll recognize you. Any questions? All right, Lisa, go ahead. Unmute yourself. What's your question? Lisa Tarbell?
Yes, hi there. I'm wondering if there are any existing public comment campaigns happening through WeAct or through Yale or alternative systems that we can find and latch onto as we prepare for IANPR to potentially come out. Thanks.
So I can start, and Anna, one of my students, is on, and Kerene, you can also jump in.
Yep.
So in the advance notice of proposed rulemaking, there was not a mobilization, because the idea was to try to say, leave things as well as they are. Like, there's no reason to change this. So people didn't want to draw too much attention to this proposal to change the rules. Now, however, if they come out with a notice of proposed rulemaking where they're going to cut back on cumulative impacts or cut back on opportunities to participate, it'll be really important to do a mass mobilization, really important to put as many comments into the record, to slow things down, and to require that they respond to your concerns. So to get a jump on that, WeAct and our team at Yale, Anna, who's on the phone, and Jesse, look through all the comments that industry put into the record on the advance notice of proposed rulemaking, or at least many of them, and tried to anticipate what their comments were. And also, WeAct had put in some comments, again, consistent with the strategy. They were thin, but some comments, and there were a handful of other comments on behalf of communities to really get a jump start on what are some of the concerns, what are some of the arguments on the other side, and how can we best promote a strong NEPA, including making arguments that if you have a strong NEPA, it prevents litigation down the road. We're going to keep working on those, and we'd love case studies. If you have examples of why NEPA is so important, definitely let Kerene or me know. But that's a piece of a larger story. People have to, I'll leave it to Kerene as to whether you've done more thinking about how to organize a more mass mobilization. The comments and encouraging people to comment on their own as well as join our comments is only a starting point for engaging people.
And I'll say, in terms of beyond what Marianne has shared, we definitely want to figure out how to increase community level interaction around NEPA when the advance notice of proposal and everything, rolls into play. So we'll be, trying to figure out maybe like easier ways to interact with folks that, whether it's, some type of form online or just a quicker way to capture it, or even the postcards as an example. We'll be trying to figure out easier ways for people to participate.
Hi, everyone. Just to add something, I'm Anna. I'm Marianne's student at her environmental justice clinic, and we've been working on a draft focusing especially on cumulative impact and protecting and strengthening this analysis, and also public participation. But we're still anticipating the arguments because the NPRM still hasn't come. So the next team, when we graduate, will take on, and we'll continue working on that, and we'll share the comment that we're allow any other suggestions you
Yeah,
may
Any
have.
other
two
questions?
other just
Thanks,
quick
Lisa.
comments.
Go.
I was just going to say we will make sure everybody knows when it comes out. So that's one thing, is kind of rapid response.
Noted.
And the other is there's some great models for mobilizing. But we can talk more about that as time goes on.
And there are some pieces out there. It's not specifically about the NEPA aspects, but there are some great documents online and available through EPA's Office of Air Quality Planning and Standards. That's OAQ as in Queen PS, on effective public commenting, guides to including environmental justice perspectives in public commenting, how to give effective public comments. So we've done a lot of training in that space. It was specific to a variety of air rules, but the general proposition about how to give effective public comment, how to write and structure effective public comment, how to use public comments as an organizing strategy, or the public commenting process on rulemaking, are available on their link on EPA's website. It's OAQPS, the Office of Community and Tribal Engagement, I think.
Yeah, and there was this great example when trying to address this administration's rollback of protections against sexual harassment and sexual violence. Advocates mobilized across the country, and they had meetings, and they had postcard writing parties, and they got college campuses involved. And that level of mobilization produced a huge number of comments that was really very effective. And so looking to some of what other groups have done to try to influence rulemaking recently could also be a good idea.
Yeah. Any other questions? We are now at 3:02, so just for respecting your time, this will be the last question. And if not, please feel free to email our communications manager, Dana, DANA, at weact.org with any additional questions or concerns about the webinar.
Did we mention the other publications and resources that people can go to that might be helpful?
Yes, it's on the last slide. So there are links to resources that you can click onto that will have examples of success stories, and also resources like the Citizens Guide to NEPA and the Promising Best Practices from the Interagency Working Group on Environmental Justice that are really helpful.
Thanks.
I also just wanted to thank Dana and thank Kerene and WeAct for hosting this.
Yeah. Well, we definitely want to thank everyone for joining us today for the webinar on the importance of NEPA, especially as it relates to environmental justice communities. We intend on doing more of these webinars throughout the summer in what we hope to call our Environmental Justice Summer School Series. And as I said before, if you have any additional questions about what we've discussed today or future webinars or just WeAct in general, feel free to email Dana at dana@weact.org. And so special thanks to Marianne, to Vernice, to Anna and Jesse, and of course, Dana, who's on my team here in Washington, D.C. And thanks to everyone who's registered and participated. You all have a great day. Thank you so much.
Thank you all.
Thank you.